Welcome to the Affiliated Monitors Expert Podcast, hosted by Tom Fox on the Compliance Podcast Network. In this episode, I visit with Affiliated Monitors Managing Director Don Stern, and we take up the topic of
how can a defense attorney work proactively with an independent monitor? And I was wondering if you just could start off with your observations on that.
Sure. Traditionally, defense lawyers, and I have been on that side. I've been both a government prosecutor, federal prosecutor, and also a white-collar defense lawyer. And I think it's fair to say that traditionally, defense lawyers were very wary about getting compliance professionals engaged and involved in assessing a company's compliance plan in the midst of an investigation while things were active. There were witnesses to be interviewed. The government was, in some cases, was kind of all over things. That reluctance, for a lot of good reasons, has gone by the boards, or at least should be. And part of that is that the Department of Justice has made clear that they don't want to see improvements in a company's compliance program wait until the investigation is completed. I think at this point, the worst thing that a defense lawyer can do is to sit back, wait for the investigation to complete, either their own internal investigation or the government's investigation, and then say to the government, either in a self-reporting or in another context, well, now we're going to fix things. I think it's important to get in there as quickly as possible, and we could talk about it during the course of this five-part series. But the Department of Justice, as recently as a couple of months ago, has made clear in a change in policy, or at least an articulation of policy by the Assistant Attorney General in charge of the Criminal Division, that the improvements and the investments which a company has made in the corporate compliance program is something that they can take a close look at in deciding how to proceed, including whether to have a monitor or not. And they're also interested in what remedial steps have been taken. And whether they've been tested by independent third parties. So you just can't sit back, sit on your hands, hope for the best, and then, if pushed over the cliff, make changes. You've got to be proactive, assess the situation early on, and make those changes yourself.
Don, I've done a little bit of this type of work, and one of my observations was that the skill set that I brought as a compliance professional who never practiced, who's never ex-DOJ, never practiced on the defense side as you have, are really a different set of skills than your traditional white-collar defense lawyer. Would you believe that a fair assessment? And if so, would it lead to you suggesting that a company bring in a true independent compliance professional in this monitor role?
I think there's some similarities, but I think you make an excellent point, and there are some differences. So when I came to Affiliated Monitors, I've been doing this with Affiliated Monitors for almost 6 years. I did have to make some adjustments, because you come in as a white collar defense lawyer. First of all, your goal is to some extent protect the company, and you're really not interested in kind of getting into the weeds of compliance. You're getting right to the heart of what's the problem, what's the precipitating cause, what's the government going to be looking at. When we come in wearing our compliance hat, it's different. We're not really interested in pointing fingers and replaying history. We do care about what some of the problems are, but it's a much more future-oriented assessment, Tom. I mean, we're dealing with, what are the controls? How can you prevent problems? Not what necessarily are your existing problems, although that's part of it. And so the skill set bears some rough similarities to what a lawyer would do in a similar situation, but it's different enough so that having somebody who is well-schooled in compliance programs, well-schooled in controls, is able to kind of bring out from employees at all level what their concerns are, is different enough so that it helps have somebody who's done it before and knows what they're doing.
So before we have any words about the full remediation, I was wondering if there's an interim step that the independent third-party monitor can bring along the lines of benchmarking, and how would that work with a defense lawyer?
Well, I think when you bring in somebody, like Affiliated in a situation like that, I think there are a couple of different goals. I mean, there are probably 3 or 4 goals that you have or should have. The first is to fix things. So, it's a little bit like putting your finger in the dike. If you find out there's a serious problem, it could be the problem in the branch office in Toledo or in Southern California, or it could be with some rogue employees. You want to fix things. But the second goal, in my view, is to do some benchmarking. How do we match up with best in class, with best practices? I think that's important. And we, and a company that's been down that road before in a variety of different industries can help you do that. The third goal, and this is, I think, often overlooked, you send a very important message internally within the company. When you bring in a third-party independent, as opposed to just having your HR department or your in-house counsel or even regular outside counsel, you send a very powerful message to employees that this is important to us and we care about it and we want to listen to you. And you can tell us things that you might not feel comfortable telling people in-house. And then the fourth goal is to tell the government if you ultimately self-report or if it's in the context of an ongoing investigation, you're telling the government, we get it. We understand that we have to be better. And we're not going to wait for you to beat us over the head and tell us we have to do it. We care enough about this so that we're going to invest our own resources and our own time into identifying the problem now and trying to fix it. And so it's a little bit of a insurance policy. You want to fix the problem, but you also want to send a message, not only internally, but outside the company, that we kind of get the message and we understand that compliance is important.
Don, you touched on this briefly a little bit earlier, but I wanted to maybe expand a little bit. Why is remediation so important in dealing with the government at this point, based upon what you've heard from not only the Department of Justice, but the way the new FCPA corporate enforcement policy works?
I often thought, even when I was a federal prosecutor, and then I thought the same thing as a white-collar defense lawyer, that the goals overlapped. Sometimes you're on different sides of the bench, so to speak, so both sides don't necessarily see that. But there is a shared goal in making corporate culture and corporate compliance better. I know it doesn't seem this way from the defense point of view, but prosecutors really do want companies to obey the law and to comply. And white-collar defense lawyers, really share that interest in having companies obey the law and be in compliance. What the Department of Justice has articulated and done is exactly that, which is if you want to sort of keep out of our line of sight, or even if you are in our line of sight, if you want a better outcome, worry about compliance. And we don't want it to just be a paper program. One of the things that I've seen, and I'm sure you've seen this too, Tom, is that the government has become much, much more sophisticated in assessing compliance programs. It used to be that you can simply present the policies and the procedures and some of the metrics, and the government, the prosecutors or the regulators would nod their head and say, well, look, you got a very good program. Not anymore. They want an assessment, on-the-ground assessment, as to whether it's really working and whether people take it seriously. And the best way to do that, in my view, is having a third-party independent come in and do that work.
Don, unfortunately, we are near the end of our time for this episode, but I've been visiting with Don Stern. I hope you will join us again in our next episode where we look at the nuts and bolts of how this works. Don, thank you, and I look forward to continuing the conversation.
Great. Thanks, Tom.
Hello, everyone. This is Tom Fox again. I hope you enjoyed this episode in our 5-part exploration of the benefits of independent monitoring and of proactive assessments for defense lawyers. I hope you'll join us again for another episode where I visit with Don Stern. This special 5-part podcast series with Don Stern of Affiliated Monitors has been a presentation of the Compliance Podcast Network. You can learn more about Affiliated Monitors Their website, www.affiliatedmonitors.com.